Good evening. My name is Caitlin McClune, and on behalf of the Board of Student Advisors and Dean Minow, I want to welcome you to the final round of the Ames Moot Court competition. The case before the court tonight, Garfield versus United States, was written by Elizabeth Preliger and Tajinder Singh of the Harvard Law School class of 2008. The case presents two questions. First, whether the Stolen Valor Act, a statute that authorizes a prison term of up to 1 year for those who lie about receiving certain military honors, is invalid as applied to petitioner Otis Garfield under the Free Speech Clause of the First Amendment. Second, whether Garfield is entitled to resentencing because the district court deprived him of his right to speak at sentencing in violation of Federal Rule of Criminal Procedure 32. Petitioner Otis Garfield is represented by the Honorable John McCarthy Roll Memorial Team, consisting of Avis Bolin, Adam Hollowell, Jessica Palmer, Yvonne Sadie, Matthew Scarola, and Benjamin Watson. Adam Hollowell and Jessica Palmer will be making oral arguments on behalf of the team. The United States is represented by the Belva Ann Lockwood Memorial Team, consisting of Carolyn Anderson, Matthew Greenfield, Stephen Petsy, Mitchell Reish, Stephanie Simon, and Noah Weiss. Carolyn Anderson and Matthew Greenfield will be making oral arguments on behalf of the team. The Honorable Sonia Sotomayor, Associate Justice of the United States Supreme Court, will preside as Chief Justice of this final round argument. Joining her will be the Honorable Frank Easterbrook, Chief Judge of the United States Court of Appeals for the Seventh Circuit, and the Honorable Peter Rubin of the Massachusetts Appeals Court. Judge Rubin graciously stepped in last night to judge the arguments when unforeseen circumstances prevented Judge Reinhart from joining us tonight. Our sincere thanks to him for joining our distinguished panel. No photography of any kind is allowed at any point before, during, or after the argument. We ask that you please remain seated while the oralists are speaking, and please turn off all cell phones at this time. Please hold your applause until all oralists have finished speaking, and remember that the petitioner will make rebuttal arguments after the respondent has spoken. Best of luck to both teams, and enjoy the argument.
All rise. The Honorable, the Chief Justice, and the Associate Justices of the Supreme Court of the United States.
Please be seated.
Oyez, oyez, oyez. All persons having business before the Honorable Supreme Court are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court.
Petitioner, are you ready?
Madam Chief Justice, and may it please the court. My name is Jessica Palmer, representing petitioner Otis Garfield. I will address the constitutionality of the Stolen Valor Act. We would like to reserve 3 minutes for rebuttal. 2 terms ago, this court held in United States v. Stevens that the government could not use an ad hoc balancing test to strip constitutional protection from speech. Today, the government asked the court to depart from that holding, as well as its holding in Brown v. EMA, and instead give the government unprecedented leeway to prescribe speech within an unprotected supercategory of speech. But Otis Garfield was engaged in non-fraudulent, non-defamatory false speech, a category of speech this court has never held unprotected. However well-intentioned, the constitutionality of the Stolen Valor Act, as applied to Otis Garfield, is simply not sustainable under this court's...
Why are you calling this an as-applied challenge as opposed to a facial challenge? What do you see as the difference, and what construction of the statute do you think would make it constitutional in a different situation?
Madam Justice, we recognize that the elements of a facial challenge and an as-applied challenge are very similar. And under Citizens United, we think should you decide to make a facial ruling on the statute today, you certainly may. But the remedy...
Well, we could do whatever we choose when it comes to interpreting a statute.
Of course, Madam Chief Justice.
However, but the point is, what do you see as the difference? What argument are you using that would be different in one situation as opposed to the other?
Well, we're focusing on the remedy that we would like to ask for, and the remedy is reversal because the statute is unconstitutional as applied to Mr. Garfield. Mr. Garfield, as I stated, was engaged in non-defamatory, non-fraudulent speech. He is not an employee of the U.S. government. He is a private citizen opining on, in a private space with, other civilians, and he is not subject to a variety of circumstances under which potentially the Stolen Valor Act could be constitutionally applied.
So you don't make an overbreadth challenge?
We do not. We argue instead that as applied to a civilian, speaking to other civilians in a civilian context, and whose speech is not shown to be in any of the categories of unprotected speech heretofore described or listed by this court in Chaplinsky, RAV, Stevens, and other cases.
So why isn't this a fraud? Didn't he lie to women, asking them to rely on those lies for purposes of securing a date? And didn't he harm them because I know that my time's valuable? I'm assuming yours is. So there's injury. So why isn't this a fraud?
Well, at first, Madam Chief Justice, there was no showing below as to the elements of fraud. There are no findings in the record as to that conclusion that this was fraudulent. There were no allegations of fraud made, and if the court...
What allegation was missing to make this a fraud?
Well, there was no harm.
Why is harm essential to fraud?
Well, should this be a situation of fraud, it would have required that there be a misstatement of material fact.
Yeah, but I understand fraud to mean an intentional misstatement of a material fact, which does not require proof of harm. If you think about lying on your balance sheet made to obtain a loan to a bank, the fact that the bank ignores your balance sheet doesn't make it not fraud, even though if the bank doesn't pay any attention to your balance sheet, there wasn't any harm. So why is harm essential to fraud?
Well, I think that the type of situation that we could see very clearly fraud taking place were had Otis Garfield attempted to secure money from these women, had he attempted to secure something from them, intended them to rely on his statements to get that and done so. It is not even clear.
Trying to get money is certainly one kind of fraud, but not the only one. Let me ask you about a similar kind of statute. Suppose Congress passes a law which says that no one other than the Olympic Committee can use the Olympic symbol of 5 interlocked rings, not because anybody will actually think that these other users are the Olympic Committee, but because it dilutes the value of that symbol. Would there be any First Amendment problem with that?
Well, we do understand that there is a dilution argument here that was raised by the government as well as raised below in Alvarez. And
Could you address my question?
I'm sorry.
Would there be any problem with a statute saying that no one could use the 5 interlocked rings, the Olympic symbol, even though they weren't trying to get money from the Olympic Committee, and even though nobody confused the user with the Olympic Committee? In other words, it's an anti-dilution requirement, and anti-dilution rules are common in trademark law. Any problem under the First Amendment with an anti-dilution rule?
I'm afraid I'm not familiar enough with the situation of the Olympic Committee to say. Insofar as the Olympic Committee is identified...
You may know that this court addressed that question in 1987.
Yes.
We rejected a First Amendment challenge to that statute and said there's no problem under the First Amendment with an anti-dilution rule. Now, if I understand the rationale for this statute correctly, it's essentially an anti-dilution statute. Because nobody can dilute the value of these metals by claiming to have one if you don't. kind of like diluting the value of the Olympic trademark. And I'm wondering why, given the outcome of the Olympic case, this situation is different.
Yes, sir. I believe that the difference relates to the nature of the U.S. government attempting to preserve a symbol that it has defined.
A symbol like 5 interlocked rings.
Exactly like 5 interlocked rings, except that the symbol in this case, a military medal.
Is there a trademark on the Navy Cross?
I don't believe so, Your Honor. I'm not aware of it if there is.
Was your client prosecuted under a general fraud statute? I assume there are fraud statutes that apply to all types of fraud. Was your client prosecuted under one of those?
He was not. And we are not addressing a situation in which he had actually been prosecuted under a fraud statute. We mentioned in our brief that there is a pending amendment to the Stolen Valor Act to require it to pertain only where there is an intent to secure something of value. And that would, we believe, amend the Stolen Valor Act to be a fraud statute. As it stands now, it is not. The court would need to
Do you think that law would be okay?
We do not contest the constitutionality of that law as written, but
I'm not asking you that. I'm asking if you think it would be constitutional.
we concede that it probably would.
What do you do about RAV?
RAV is a difficult situation, but in that case, if you were prescribing the speech on the basis of its fraudulency as part of a category of fraud that is unprotected for that reason historically, then you would be prescribing a subcategory because you found it to be a particularly harmful variant of the overcategory of fraud. So if it was shown, if the government made findings that fraud executed through claiming to have a military honor one did not have was an especially pernicious variant.
Who would make
of
the
fraud,
findings?
The government would, I assume, prosecute and then ask this court to approve that rationale. And this court could do so, or this court could say under RAV that that was not an acceptable subcategory. The intent of RAV was to ensure that the government did not abuse unprotected categories of speech in order to disfavor speakers.
Can I ask you a question?
Yes. Please do.
Very accommodating.
I guess that's probably right. When can a false statement of fact be actionable as an intentional infliction of emotional distress, if ever?
We believe that a false statement of fact can be actionable as intentional infliction of emotional distress under state tort law. So that would depend on the state. And we believe that it is not allowed where the First Amendment has been established to where the First Amendment has been extended to ensure that there is no suppression of speech. For example, in Time v. Hill, a case cited by the government against us, essentially what happened there was a novel category of unprotected speech was not carved out. Snyder affirms that IIED is not a novel category of unprotected speech. Instead, what happened was I'm sorry, I misspoke completely. I was referring to Hustler.
Yes.
I'm afraid that Justice Easterbrook has me somewhat rattled. Likewise, not an unprotected category of speech. So essentially, footnote 3 of Snyder v. Phelps dismisses the assertion that IIED is an unprotected category of speech.
I don't understand what you're saying. I asked you if someone's false statements of fact, like a relative of yours is a terrible felon, your parent is a terrible, terrible felon, and I know that's not true, and I say it repeatedly. I say it to you. I rent a billboard, and you bring a cause of action against me saying that I have intentionally inflicted emotional distress. Can I defend on the ground that, well, it's a false statement of fact, and it's not defamatory of you, at least? Can you bring that action against me?
Yes, I believe so. I'm sorry if I was confusing, and of course my citation to the completely wrong case did not help matters. But essentially the way we see it is this. Hustler sketched out a rationale in which the plaintiff made two claims, a defamation claim and a claim for intentional infliction of emotional distress. And the court said, under Sullivan, you cannot recover for libel or defamation against a public official or public figure because of the overriding considerations of the First Amendment, unless there's actual malice. And then Hustler v. Falwell.
Actual malice. So there's knowing falsity in my statement about your parent. So it's a lie, it's untruthful, it's not defamation, it's not, I don't think, it's not fraud, but it's actionable, right?
If it's made with actual malice, if you are a public figure, then yes. I mean, I think the overriding...
Well, I assume you or your parent, whatever, are private figures, so it would be even stronger case, wouldn't it, for the constitutionality of that tort cause of action?
I believe that unless you were dealing with a situation such as in Snyder v. Phelps, where it was speech on a matter of public importance in a situation that the government had authorized for that type of speech, a public area complying with the time, place, and manner restrictions for protesting, unless it was a sort of situation where overriding First Amendment concerns protected public debate, you would have a state tort cause of action. We do not claim...
You seem to be borrowing the government's argument, the breathing space argument, and you were rejecting that in your brief. So are falsehoods that inflict injury, emotional injury on a private person actionable? We said so in Hustler, didn't we?
Yes.
All right. So there may be situations, you're arguing now, in which the First Amendment might forbid that cause of action. So give me the theoretical framework that you would apply to that situation here.
The theoretical framework that we would apply here is that essentially when you're dealing with a category that has not been defined, and we believe Stevens provides the test for whether a category is historically unprotected. We believe Stevens supplies the only test, and that the government's asserted test is not valid because it assumes that false statements of fact are unprotected to begin with. We believe that within that framework, the First Amendment can nonetheless mandate the courts
How far does this history have to go back? I'm beginning to get worried about my anti-dilution case again. Anti-dilution protections were added to trademark law only in the 20th century. So does that mean they're unconstitutional because novel? I mean, most of the federal constraints that have something to do with speech, like the securities laws, are the work of the 20th century.
Well, to return to your dilution question, Your Honor, we understand the government's dilution argument makes this analogy with trademark, but we would say there's several very, very important distinctions here. First, when you're dealing with trademark, when you're dealing with a mark used in commerce, like when you're dealing with commercial speech, the government has heightened reasons to regulate that. So that is one reason why a prescription against dilution of a symbol would be valid. But
why would the government have a greater entitlement to regulate the Olympic symbol than to regulate with respect to its own military decorations?
Because regulating with respect to its own military decorations raises the specter of government suppression of criticism of the government itself. And that specter is exactly what we think motivated the court in Texas v. Johnson, that when the government defines a symbol and associates meaning with that symbol.
So if the government passes a law, I think there is one that says that no private firm can refer to itself by the initials IRS, right? Because it fears that people might cooperate with them because they think they're the tax collector. That wouldn't be allowed because the government is protecting governmental initials, and that treads on the First Amendment?
In that case, Your Honor, the government would not be protecting the integrity or objectivity or, honestly, intimidatingness of the IRS to the general public. They would be protecting the public from being misled to their harm by a corporation.
But we're back to the question why this isn't different. There's a problem of potential misleading, and there's a problem of potential dilution. One can imagine them being misused to stop political criticism of the government, But your argument, as I understand it, is that the law is invalid even if it's not used to stop criticism, but it's just used to prevent misleading innocent people into dating you, or, right, to prevent people from being intimidated in my IRS case.
We do. And if I can differentiate what we seem to be the dilution argument from the example that you're giving, the government's special concern with protecting consumers does not apply as it does in your IRS example. We're not talking about a mark used in commerce. We're talking about a mark used by the government itself. And there is no clear harm here. The harm asserted by the government, it asserts a compelling interest that is in the internal functioning of the military. It is unclear how a civilian's comments to other civilians in a civilian form affect that. There is no harm. Mr. Garfield is not like a counterfeiter or maker of counterfeit luxury items. He's like someone who can't afford them but claims to have them as an aspirational matter. And he might try to impress people with those claims, but those are idle boasting. And this court has never held that idle boasting in the private sphere is unprotected speech.
The problem is that the anti-dilution statutes don't require confusion. They assume the buying public understands that the used symbol does not belong to the source using it or promoting it that's not the Olympic team. So we go back to the question of, I think the initial question that Justice Easterbrook started with, which is, why does misrepresentation, fraud, impersonation require a harm that has to be defined by economic injury alone? Why can't emotional distress, dilution, that it brings disrespect to a respected mark, why aren't those harms that would justify a statute of this type?
I see my time has expired. May I answer?
Yes.
I would say first that if the harm is merely to the governmental reputation, which is the interest asserted on the face of the statute, it should not be actionable because that treads in the territory of government suppression of speech. If the harm is to a consumer in a commercial context, this court can regulate that under a different standard using its commercial speech jurisprudence. What we have here is not a case of commercial speech. It's not a case of a mark used in commerce. It's a case of the government's own mark. And the court's precedents on the government's protection of its own symbols, Texas v. Johnson, we think govern here. We recognize the dilution analogy, but we do not think that is the correct one as applied to the speech. Thank you.
Madam Chief Justice, and may it please the Court. My name is Adam Hallowell, and I will address the denial of Garfield's allocution. The defendant's personal right to allocute protects the ability to seek mercy and mitigation at sentencing, and empowers the defendant to express an individual perspective within the criminal justice system. This Court made clear in Green v. United States and its progeny, and in keeping with a centuries-long tradition, that denial of allocution leads to reversal of the sentence. But even if the court abandons that position, it should vacate Garfield's sentence under Olano's plain error test. Firstly, Green controls this case. Green required automatic reversal of allocution errors because nothing can substitute for the halting eloquence.
It's hard for me to say that that's what it held, when in fact the holding of the court was that there was no violation on the facts of the case before it. Some of us call that dicta.
Well, that's
that they suggested that we should be remanding if a violation had occurred when the holding was that one hadn't.
That's true, Your Honor. Green did not provide a remedy to the defendant in that case because it did not find a violation of Rule 32 in that case. However,
and was there any argument about Rule 52 in Green?
No, Your Honor.
By the litigants?
There was no.
So how could there be a holding on an issue that the litigants never contested?
First, Your Honor, Rule 52 was enacted 17 years prior to Green.
I know, but it's just a general question. How can this court be deemed to have held something on a question that the litigants never contested and that wasn't discussed in the court's opinion?
Well, first, Your Honor, we believe that Green states the remedy, but the holding is from Van Hook.
My general point is it's very common for this court to grant certiorari on a particular question and resolve that question. There are lots of other questions that might have been raised in Green, but the Rule 52 question was not an issue raised in Green. And we don't have holdings on issues on which we didn't grant certiorari, the parties didn't brief, and we didn't say anything about. It seems to me a straightforward proposition.
That's entirely true, Your Honor. If Green were this court's only case on allocution, this case would be more difficult. However, two cases decided in the immediate wake of Green make clear that...
Did we discuss Rule 52 in either of those cases?
No, we didn't, Your Honor.
Did the parties brief Rule 52 in either of those cases?
Apparently not, Your Honor, but Rule 52
Same
is...
problem.
Can I ask you? I'm sorry, you can answer. Please answer.
I'm sorry.
Okay.
We believe that because Rule 52 was 17 years old at the time and was applied by this court in several different cases around that time, in 1958, 1962, we believe that it was clear that the failure to apply Rule 52 and the summary reversal of an allocution error in Van Hook makes clear that, as Hill stated, the remedy for an allocution error on direct review is automatic reversal.
If we find that that's not what we held and that we have an open question before us, what category of errors is it that you say require automatic reversal even when the claim has not been preserved or has been forfeited below?
Well, Your Honor, Green was not writing on a blank slate. Green was instead responding to a 3 centuries old tradition from the English common law dating back to at least 1689.
But my question is, what is the category in which forfeited errors must be automatically reversed without plain error analysis?
We would say errors having such a historical pedigree of
Okay, so the one case you've cited is the Wynn case?
Yes.
Okay, so you think that there's a historical pedigree that you can't have a non-Article III judge on an Article III court, I guess.
That's true, Your Honor.
I suppose that probably goes back to Article III.
Well, the holding in Wynn was a statutory holding. The court didn't reach the constitutional question in that case.
Okay, and another one that's many centuries old is allocution.
Yes, Your Honor.
What else?
I'm
trying to figure out why your automatically reverse forfeited claims of error, why that doesn't just swallow Rule 52 right up.
Well, Your Honor,
aren't many of the things associated with criminal trials ancient?
We believe that the reason that Green has such an extreme remedy is because it is not only directed towards prejudice, which this court addressed in Alano. It also serves a unique participatory function within the criminal justice system. It allows the defendant to speak at sentencing and to feel that his perspective has been addressed by the court. It serves values of transparency.
If those values were so strong, if they were fundamental to a fair trial, then why did we hold in Hall to the contrary?
Well, Your Honor, our understanding of Hall is that habeas cases, the general standard for habeas review is a requirement that the record be insufficiently developed on direct appeal for courts to understand, for a reviewing court to properly review the question below. That's why questions of ineffective assistance of counsel are generally reviewed on habeas review and claims tend not to be heard on direct review. That isn't the case for allocution errors because the error is obvious from the record in this case. The judge simply omitted to address the defendant personally to allow him to allocute. And for that reason, we believe that Green states the proper remedy in this case.
I guess my problem is, if in Hall we hold that the right of allocution is not a constitutional right.
That's true.
And because of that, we say it's not cognizable on habeas review. Basically, we're saying it's not a structural defect. It's a statutory entitlement. And so we go back to Justice Rubin's question of how do you elevate one statutory requirement over another? and say that some require automatic reversal, but most others don't?
Well, Your Honor, we would point again to the inherent value of allocution in providing the defendant to address the court. It's an in-kind guarantee, if you will, of fairness within the criminal justice system. And
Let's say we decide we have to apply Rule 52. Can you argue, and let's say it's plain and obvious, as you say,
yes.
It still has to affect substantial rights, and it still has to, whatever the fourth test is, affect the integrity of the proceedings. Can you argue if we go to Rule 52, do you just lose, or
no, Your Honor?
Can you make those showings as well?
We can and do argue that we satisfy Olano's plain error framework. On the prejudice standard, the third prong of Olano, while the prejudice prong generally requires a demonstration of an individual effect on Garfield's sentence, we believe that the proper approach in this case is for this court to apply a presumption of prejudice to allocution errors.
Could it ever be overcome?
I'm sorry?
How would the government overcome that?
The government could overcome that presumption by showing that the error could not possibly have affected the outcome of the proceedings, the sentence.
In what case have we applied a presumption of prejudice in a Rule 52 plain error inquiry? There's certainly quite a lot of cases in the past 20 years where we've held that that's inappropriate. Are there any where we have applied such an approach?
This court hasn't, in its 8 or so cases that have applied Olano since 1991, held a presumption, but it's still left open.
And we have reversed courts of appeals several times for adopting such a presumption. They didn't get very far. Why would this, for example, Vaughn is a case saying there shouldn't be such a presumption for violations of Rule 11. Why should there be such a presumption for violations of Rule 32 but not for Rule 11?
Well, Your Honor, we believe there are several points in favor of a presumption for Rule 32 errors. They tend to cause significant prejudice in any given case.
Look, I understand your argument just
yes.
viewing Rule 32 in isolation. I'm
yes.
asking you to take Rule 32 in the context of Rule 11. One reason I'm asking you to do that is not only because Vaughn involved Rule 11, but in Timrek back in 1979, we held, at least so I read Timrek, that Rule 32 and Rule 11 should be treated alike for this purpose. Do you have any way around Timrek?
I would point, Your Honor, to the fact that Vaughn made clear that the prejudice could be shown not to have occurred in that case, and that was the rule.
Of course it was possible, but there can't be a presumption of prejudice. But I hope you understand my question. I'm asking why Vaughn says no presumption of prejudice under Rule 11. Timrek, back in 1979, says that for purposes of reviewing claims of error on appeal, we are going to apply the same approach to Rule 11 and Rule 32. You put Vaughn together with Timrek, it seems to me you have a problem, and I was wondering whether there was a response to that problem.
Your Honor, I think the plain response would be that Timrek preceded Olano, and so what Vaughn's application of the Olano framework may make an open question whether or not Rule 32 and the inquiry into prejudice that Rule 52 requires should be treated the same as Rule 11. And we think that because allocution errors can rarely be shown to be non-prejudicial in the fact that a defendant's request for mercy could always have an effect on the decision maker.
So as a practical matter, it's exactly the same. If we say that it's a forfeited error, but that gets automatic reversal, or if we apply Rule 52 and say we presume prejudice, except in a case where mathematically the sentence couldn't be any lower than what was given, we always have to reverse. Is that right?
Not at all, Your Honor. Because of Olano's fourth prong, the fairness and integrity prong, the inquiry would be different under those approaches. And even bracketing the question of individual prejudice, which we argue can be shown in this case, because the judge indicated on the record that whether Garfield had expressed remorse and accepted responsibility was a difficult issue, which could have been addressed on his allocution. We believe that
I think basically his words were, I'm assuming that was the reason for his actions. but I'm giving him this sentence because all he does as a pattern of life is lying. So what is it that you expected your client to prove to the judge?
Well, Your Honor, our client could have expressed his expressed his remorse, could have more clearly demonstrated that while he did not regret making his political statements in the way that he did not intend to break the law in the future. And those would have addressed the deterrence concerns.
In our Apprendi line of cases, where we found, implicitly or otherwise, that sentencing a defendant to a sentence above the statutory maximum was substantial prejudice. We still went to the fourth prong and looked at the evidence and said, despite the failure of a jury to find the drug quantity beyond a reasonable doubt, we're not going to overturn the conviction because the evidence was overwhelming. If we apply that same approach here, tell me what non-overwhelming evidence there is to show that the judge would or might have given a different sentence.
Yes, Your Honor. You're referring to Cotton, and we distinguish Cotton in several ways. First, as a general matter, in sentencing, there can never be a showing that the evidence was overwhelming that a particular sentence, as opposed to a sentence slightly lower, would have been appropriate because of the discretionary sliding scale of the sentencing approach. But secondly,
well, you haven't proffered that your client was going to say anything different than what was in his letter, correct?
We can't account for motivations of counsel below in placing that evidence in the record or not, but we believe it's very clear.
Did your client make an offer of proof?
I'm sorry?
Did your client make an offer of proof?
I
Right?
don't.
Your brief speculates a lot along the lines of, well, my client could have said X, right? He could have contradicted the letter his lawyer read. Could have said X, and that would have helped him. Normally, when the legal system worries about things people could have said, it depends on an offer of proof. So here, the normal means for an offer of proof would be immediately after your client is sentenced, he files an affidavit saying, I wasn't invited to give allocution. Had I been invited, this is what I would have said. Did your client do that?
No, Your Honor. That's not in the record that our client did that. However, we believe that because Garfield was a first-time offender, because he had not engaged in a plan of violating the criminal law to spread his anti-war message, because of these factors, he was a first-time offender with no criminal history, and yet because he was in part because of concerns about deterrence and because of concerns about his personal history and the probability that he would lie in the future, the government the judge in this case sentenced him to 3 months of jail time and 6 months of supervised release. That's an extremely harsh sentence for a first-time offender, and we believe that for a case where no prison time at all would have been appropriate. We believe that threatens the public integrity of the proceedings, that he did not have a chance to address this court on those questions of the state of mind. And for those reasons, we would ask this court to reverse the sentence. Thank you.
Chief Justice Sotomayor, and may it please the court. My name is Caroline Anderson, and I represent the United States. I will argue that this court should affirm the lower court's holding that the Stolen Valor Act is constitutional as applied to petitioner. My colleague Matthew Greenfield will address the allocution issue. Today, the government asks this court to do only that which it has done many times before, to apply the tradition recognized in New York Times versus Sullivan to a discrete context. Here, knowing lies regarding the receipt of military medals, rendering them categorically outside of the First Amendment.
I'm a little troubled by the categorical argument. One of the characters in Joseph Heller's anti-war novel, Catch-22, is promoted to captain and given a medal, and then he's offered a promotion to major and another medal. And you couldn't dramatize Catch-22 without showing the medals, which of course the actor never received. If a false claim of having a medal is categorically outside the First Amendment, wouldn't that prevent anybody from making a movie of Catch-22 and a lot of other things that are critical of the government?
No, Your Honor. The plain meaning of the act, the meaning of the word misrepresent, according to Webster's third dictionary, is that one misleads. Now, in the context of a film, the actor does not mean to mislead the audience into thinking that he himself, that particular actor, has won a medal. So that situation is not implicated today.
Well, I understand that that's a potential response, but that's a different line of response from your categorical argument. Now you're not saying that lies about military medals are categorically outside the First Amendment. You're saying that it's intent or how the audience understands the claim or something like that. But it's a different argument, maybe a better argument than the categorical argument. But I was trying to draw out the implications of your categorical argument and see whether you really meant it.
Your Honor, to be clear about the category the government proposes today, it would apply to intentional or knowing lies regarding the receipt of the military.
Oh, in Catch-22, it's a knowing lie. Nobody believes that the actor playing Yossarian actually got that medal for being a bombardier in World War II.
Fair enough, Your Honor. We can read into the statute that which is what it read into fraud statutes, the capacity to deceive. Now, if this would save the Constitution...
So it's an attempted fraud statute?
No, Your Honor. We believe that under Madigan, fraud statutes require the obtainment of a pecuniary interest. That is not implicated today. The court, every time it has encountered a restriction on falsity, has recognized that falsehood themselves are constitutionally valueless.
So your category is knowingly false statements?
No, Your Honor.
That is the unprotected category?
I'm sorry to interrupt. No, Your Honor. The unprotected category, which we propose today, is knowing lies regarding the receipt of military medals.
But there's no history of that. This law was only recently passed.
Your Honor, there is no statutory history. It was recently passed, but this is not a requirement. It merely is evidence of the notion that this sort of law would never have been thought to raise constitutional objections. That was what...
So what's the scope? I noticed that you talk about valueless speech, and sometimes you talk about, on the other side, the state's interest. How are those different, and what's the category if it's not all lies?
Your Honor, the category is knowing lies regarding the receipt of military medals.
But you just said that that's not the category, that there's no history about that, but it's within a category that has long been thought regulable.
Your Honor, it is within a tradition that has long been thought regulable. That is what is required under Stevens and Brown. It is a new category.
Can you lie about other things?
Can one lie about other things?
Could a statute, yes, could constitutionally protected, could one lie about other things?
It would depend on the wording of the statute, Your Honor. If there were a legitimate interest advanced by the statute, and if the statute presented no chilling concerns with respect to protected expression, then yes, the court...
So if the interest were strong enough, so Congress has an interest in protecting marriage. Could they pass a law, the Defense of Marriage Act, that would prohibit spouses from lying to their spouses about whether they're having affairs?
Your Honor, it's questionable whether that interest would be conceived of as legitimate, and we can look to the circuit...
You think that's not a legitimate interest, protecting marriage?
It is a legitimate interest, Your Honor, but the ban would have to serve that interest. Now...
This ban will serve that interest.
Your Honor, if we stipulate for the purposes of this hypothetical that the ban would serve that legitimate interest, then the court would look to whether there were any chilling concerns with respect to protected expression. If the ban implicated unintentional falsities, some sort of lie about an affair which was not made with reckless disregard for the truth, then chilling concerns would be implicated.
When people don't think they're having affairs but are. Or think they're not, or think they aren't.
Excuses.
This is beginning to sound like the ad hoc balancing that the Solicitor General advanced on behalf of the Crush video statute in Stevens, and I thought our opinion in Stevens said we can't have ad hoc balancing like that, trying to figure out whether this is a good enough law, that if we were going to have a categorical exclusion, it had to be got at in some other way.
Your Honor, the Stevens court rejected an all-purpose balancing test, which would have permitted...
But that's what it sounds like you were giving in response to my colleague's question.
Your Honor, this test is tethered to a single tradition of prescription, the tradition that holds that valueless falsity may be prescribed, subject to the two considerations we've emphasized. This is precisely what the court did in Sullivan in the defamation context.
I thought Sullivan protected speech.
Your Honor, it protected speech or defamatory statements which were made without a reckless disregard for the truth, or that were made unintentionally. They did say, however, that had those statements been made with actual malice, with a reckless disregard for the truth, of the sort that we have today, petitioner admits on page 26 of the record that he told this lie with knowledge of its falsity. In that case, Your Honor, the Sullivan Court indicates that the speech would be outside of the First Amendment.
Except that both in Sullivan and Gertz, what you're missing is the other side. It wasn't merely the lie. It was the lie with the proven harm.
That's
in
correct.
In both cases, we noted that defamation harms reputation, and that's why we're protecting it. What you haven't proven here is that on the face of this statute that any harm is required.
Your Honor, there are two responses to that. One, we believe that there is harm in this case, and that is to the integrity of the military medal system. Secondly,
Well, you can't seriously argue that anyone values the Naval Cross less because there are some imposters. It's still a highly sought-after medal by people in the Navy. And for those who wear it, having earned it, their respect is not diminished, or respect for them is not diminished by these imposters.
Your Honor, we do advance this argument. It's precisely what the legislative findings indicate. They say that lies undermine
Well, show where's the evidence for that?
Your Honor, the evidence is...
Other than you can say anything you want. The question is, you can draw whatever conclusions you want, but what's the evidence that proves that?
Your Honor, we have the legislative findings, which were, it's worth noting, sufficient in the Holder versus Humanitarian Law Project, very similar sorts of findings. And in addition, we know we can defer to the military themselves, who describe the importance of the military medal system and an integrity, a system that has integrity.
Could we stop someone, make a law, it's unlawful to lie about the conduct of a war in which America is involved and use it to prosecute someone who, during the Vietnam era, maybe got up and hyperbolically, but knowingly falsely said, for every Viet Cong person that's killed in Vietnam, 100 civilians are killed. And he knows that's false. That's an outrageous, disproportionate lie. Could they prosecute that to protect the reputation of the military?
Your Honor, hyperbole is not outside of the First Amendment.
Knowingly false statement. No, it's not hyperbole, it's just a lie.
Okay, if it's just a lie and not hyperbolic, which would be governed by the Milkovich decision, which rendered hyperbolic statements within the First Amendment,
okay,
there would be some concern there that it borders on seditious libel. Now, this court noted in Sullivan that the government does not have a legitimate interest in portraying itself as a faultless institution in response to impersonal attacks. Now, that sounds like an impersonal attack on government. What we have here is a misrepresentation about an autobiographical fact. In this case, it was said with knowledge of its falsity. There are no chilling concerns in this case. If we think about the chilling concerns which highlighted the Sullivan opinion.
He said he was in the Peace Corps too. Could that also be made actionable?
Your Honor, were both houses of Congress to pass such a law and were the president to sign it into effect, the court would engage in this precise analysis.
What if a woman lied about her age on the dating site?
That sounds more likely. Well, the court would engage. The court, again, would engage in this precise analysis, Your Honor. The analysis that it applies not...
We wouldn't just say, this is a protected speech, you're suppressing the free expression of the citizenry. We wonder what the interest is. Well, some guys are getting duped, they're having to pay for dinners, they didn't know, they show up and really, is that important? It's legitimate, but how important? That's what we would do?
Your Honor, this court has applied it not only in the defamation context, in the context of maliciously false IED. And
all right, tell me how we analyze it under your approach, a statement in campaign literature. Not this lie, but any other lie. Something that says, my opponent is a liar.
Your Honor,
he's lied about his political record, he's been misstatements about that and this, any other lie that you can imagine. Would your approach permit restrictions or laws that would penalize people for lying in campaigns?
Your Honor, the Hartledge case is most relevant to that hypothetical. That case found that lies on the campaign trail are within the First Amendment. They are protected if they are done unintentionally. But it implied that were the lies to be told with actual malice, they would be outside of the First Amendment, precisely because the government has an interest in protecting the integrity of the electoral process.
Politicians can't lie anymore?
But more importantly, that sometimes there are Freudian slips, aren't there? The rationale in that case was based on the freedom of political discourse. This statement was made in the context of promoting a view of the wrongness of war. But you're saying it doesn't matter what the content of the speech is, the lie, without actually causing harm, can be actionable.
Yes, Your
without
Honor.
malice in the sense of harm.
Your Honor, this court has never endorsed a methodology which has held that because an unprotected message has proximity to political speech, that it is ipso facto protected. The Garrison Court...
No, in Pickering we held that if you have speech that is false, Pickering involves a falsehood in a newspaper, it's still protected if you go through the balancing test and figure out whether the issue was one of public concern and whether or not it was or wasn't a part of your job.
Your Honor, in Pickering, the statement was not affected with actual malice or reckless disregard, as the statement here was, as the category that we propose would only include. That is relevant to our analysis precisely because of the chilling concerns to which Your Honor alludes. The Sullivan Court was concerned that if unintentional falsity was prescribed, an editor at the New York Times might censor himself from printing something he thought to be true and which turned out to be true for fear of running afoul of such a prohibition, that he would steer far wide of the unlawful zone, and in doing so that some valuable speech would be lost. The category we describe today does not implicate any of these concerns. Garfield did not think that this was true.
But is it possible that the First Amendment protects more than those concerns? That there is self-expression here or freedom of expression? I mean, people lie every day. And if we can begin to regulate without any harm or any obtaining of any monetary thing or not in a commercial aspect, if we can regulate people's daily lies because they're outside the scope of the First Amendment, to some extent, what's the point of the First Amendment?
Your Honor, it's important to note that the court already has regulated prescriptions on falsity which contain no harm element. Here it's instructive to look to the Virginia State Board of Pharmacy case, which said that the government may regulate intentionally false commercial speech precisely because it, one, has a legitimate interest in protecting the clean flow of information, and two, because no chilling concerns would be present, because advertising is the sine qua non of profitability.
And therefore is unusually robust and is a different category from what we're talking about.
Your Honor,
although it may be dating speech is particularly robust because people want to go on dates.
Perhaps, Your Honor, that false speech is thought of as a doctrinally separate category, strengthens rather than weakens the government's position. The false commercial speech case that I described cited Gertz. It cited this defamation context because the same tradition governs. It governs in the intentional infliction of emotional distress through malicious statements context. It governs in the context of false light. It governs in the context of falsity on the campaign trail. It governs in the context of false commercial speech. That is why we ask the court to do what it has always done, to apply that tradition to another discrete context. Now, should the court be uncomfortable recognizing a new category, although we believe it is permissible because it would be well-defined and narrowly limited as Stevens requires, it may recognize either that the ban as applied to petitioner survives strict scrutiny.
Is there any reason why we need to go around recognizing new categorical exclusions? Why isn't this just another anti-dilution statute, just like the Olympic ring statute?
The court is free to consider it that way. The government here...
Though I notice that you haven't argued it. Have you forfeited that line of argument?
Your Honor, the government is only barred from making new claims on appeal under Yee versus City of Escondido, not new arguments in support of the question that was granted certiorari upon. Here we argue not only that a new category may be created, but that the court may recognize that petitioner's speech falls into the existing category outside of the First Amendment for speech integral to criminal conduct, recognized in Gibney. Garfield's speech was integral to the crime of impersonation. He held himself out as a military medal winner. He assumed this false character, and in doing so met the requirements for a valid impersonation statute as understood by 8 circuits. For that reason, the court may, in the alternative, recognize that his speech is already outside of the First Amendment without creating a new category. It also may uphold the Act as applied under strict scrutiny. The Act is narrowly tailored to advance a compelling interest in protecting the integrity of the military medal system.
So why wasn't the statute written as an impersonation statute?
Your Honor, we believe that it was crafted precisely as many impersonation statutes are. 18 U.S.C. 911, for example, which prohibits posing as a natural citizen if you are a foreign citizen, suggests that one may not misrepresent themselves as a natural citizen, just as Section 704B says that one may not falsely represent themselves as having received a military medal if they have not.
Most impersonation statutes have a requirement that you prove that you're securing a benefit from the impersonation. I know your argument here, he did. But the statute here is not written in those terms.
That's correct, Your Honor. In the 3 circuits which do require an intent to defraud, the 3rd, the 8th, and the D.C. Circuit, the government need not plead this. They may infer from an indictment as to false impersonation or false representation.
That's what most of the courts below have done to salvage the statutes. They've read a benefit requirement into it.
Your Honor, they've read the intent to defraud requirement into it, not necessarily causation. That is not required, although we believe it is present here. If the court is not willing to recognize that his speech is integral to the crime of impersonation, it may uphold this compelling interest in the integrity of the military medal system, a system which fosters a sense of mission accomplishment and distinguishes individuals, motivates troops to high levels of performance and service, as the Army regulations themselves specify in Section 6-800-22, Part 1.1. The ban is narrowly tailored to advance this interest. Petitioner argues that it is over-inclusive because on its face, it would prescribe unintentional falsity. That is irrelevant in this as-applied challenge, where petitioner does not contest that he told the lie on page 26 with knowledge of its falsity. Petitioner argues that the ban is over-inclusive because on its face, it would sweep in satirical speech. That is irrelevant in this as-applied challenge, where nobody contests that his speech actually influenced.
Counsel, I hope you'll watch the clock.
I am very sorry, Your Honor. For these reasons, we hope that the court will affirm.
Chief Justice Sotomayor, and may it please the court, at petitioner's sentencing hearing, the district court announced the right to allocution, but not by way of personally addressing petitioner. That clearly constitutes error under Rule 32 of the Federal Rules of Criminal Procedure, but because that error did not affect the outcome or the fairness of the proceeding, this court should leave petitioner's sentence undisturbed. I hope to address 3 points that support that conclusion. First, this error, like every forfeited error, is subject to plain error review under Rule 52B. Second, under Rule 52B, there is no reasonable probability that the error affected the outcome in this proceeding. And third, the error did not undermine the fairness of the proceeding. We think this court should therefore affirm. In the district court, petitioner did not object to the error he now claims. He forfeited his claim of error. This court has held—
Didn't the same thing happen in the Wynn case?
In the Wynn case, Your Honor, the error in question was one that could not be forfeited. The court in Wynn held—
It was jurisdictional?
It was a jurisdictional defect.
In the sense in which we now use the word jurisdictional, it had to do with the jurisdiction of the lower court, not jurisdictional nature, but actually jurisdictional.
Yes, Your Honor. The term before Wynn in Cotton, this court defined jurisdictional defects for the purpose of remedy and for the purpose of whether they are automatically reversible as defects that get to the statutory or constitutional authority of a court to hear a case. The Wynn court referred to the defect in that case as one that got to the fundamental authority of the court to hear the case because a non-Article III judge had been involved in a criminal proceeding. And so the court held that the error had not been forfeited and could not be subject to plain error review. It automatically reversed. The court rejected the dissent's contention that the error had been forfeited and that therefore it should have been subject to Rule 52B. And so this court has never used anything other than Rule 52B to deal with a forfeited error on appeal. Because of that rule and its universality...
What if the defendant were not present for sentencing, as required by Rule 43? Simply not there.
Well,
And for whatever reason, the lawyer failed to object, and the sentence is passed, and the defendant is literally not there.
That was the case in Behrens, Your Honor, which petitioner cites for the proposition that allocution errors are automatically reversible. But in Behrens, because the defendant and his counsel were not present at the proceeding, he simply was not held to the requirement of the contemporaneous objection rule. Plain error review exists to give meaning to the contemporaneous objection requirement.
I asked about the defendant being not present. Counsel's there. The defendant is not physically present.
If defense counsel were there, it would be our position under this court's holding in Vaughn that a defendant can fairly be held to the consequences of his counsel's failure to object, that in that case, the error would be forfeited if the defense counsel does not object. In this case, fortunately, that was not what happened. Petitioner was present. He was present when his right to allocution was announced, albeit not personally.
Counsel, in our plain error cases, in Olano and later, none of them says that prejudice is presumed, but all of them repeat the Olano formula that generally a presumption of prejudice is inappropriate, and in this situation, a presumption of prejudice is inappropriate. In the view of the United States, what are the cases being reserved or separated by that word generally? Right? Under what circumstances would a presumption of prejudice be appropriate?
Well, Your Honor's question gets to the third Olano prong, the outcome effect. We believe that when Olano says that ordinarily it would look to prejudice, it might be reserving structural errors, errors that get to the...
But as you said about Wynne, they're completely outside the scope of Rule 52. All right? If the court just doesn't have power to hear the case because it not composed of Article 3 judges, then Rule 52 is out of the picture. Olano is, I presume, not having been on the court at the time of Olano, I couldn't really say, but Olano is reserving the possibility that for a real operation of Rule 52, sometimes prejudice might be presumed, or there'd be something like that. And I'm just wondering whether the United States thinks, as it might think, that we're wrong, that it should never be presumed, but if sometime it should be presumed, what's in that box?
There are two answers to your question, Justice Easterbrook. First, structural errors do fit within Rule 52B. Jurisdictional errors do not, but this court held clearly in Johnson that structural constitutional errors are evaluated under Rule 52B, and that if the court wants to change its approach to the outcome effect, it would do so only within the third Olano prong. And so...
Is that really true? I mean, take one of the structural errors that the Supreme Court recognized in Chronic is your lawyer just doesn't show up. You're there, your lawyer isn't there, the court barges ahead with the proceeding. And Chronic says that's reversed without any inquiry into prejudice. Now, if this is actually covered by Rule 52, we could amend Rule 52, right? It's promulgated by this court. We could amend Rule 52 so it would cover the Chronic situation. You think that would be a valid amendment to Rule 52? One that says, oh, sure, we're going to affirm the conviction even if the lawyer just didn't bother to show up.
Importantly, when Chronic says that about that type of error, it only points out that the prejudice inquiry would change. The court would still evaluate, and I would admit that in that case it might be an easy evaluation, whether fairness, integrity, and public reputation were affected.
No, look, the reason I'm asking a question like this is because Rule 52 could be amended in a way that would have the rule say that in the Chronic situation it would be necessary to show prejudice. And if one goes by what was actually said in Chronic, if the rule actually said that, it would be unconstitutional. I'm interested in the separate category of things that are not structural error, not automatic reversal things like Nguyen or Chronic, that are covered by Rule 52 where there might be a presumption of prejudice. Now, maybe it is the position of the United States that this court has just been too cautious in writing usually and generally every time. But if it's If that's your view, I would love to hear that view. If it's not your view, I would be interested in knowing what you think is in that box.
Yes, Justice Easterbrook. Under the third Olano prong, it is the position of the United States that prejudice should never be presumed. This court has never presumed prejudice, and in fact, at every opportunity, it has rejected the presumption of prejudice in Olano and in Vaughn and in
So how
Puckett.
much of a showing does the defendant have to make?
The court defined it in Dominguez-Benitez as requiring a reasonable probability showing. Now,
Reasonable probability or possibility?
Reasonable probability were the words of the court in Dominguez-Benitez, and it has used those words repeatedly since then. It gave effect to that standard by calling it enough to undermine the reviewing court's confidence in the outcome of the proceeding. On the third Olano prong, the outcome prong here, petitioner cannot possibly support that burden.
Is it possible that we've viewed the purpose or have articulated the purpose of allocution more narrowly than it's been historically understood, and that we shouldn't be looking at whether the sentence would be higher or lower, but at some of the intangible benefits for the criminal justice system of having allocution in every case, of having the judge directly address the defendant, regardless of whether it would make any difference? And can we say there's a reasonable probability that that prejudice occurred?
Not under Dominguez-Benitez, Your Honor, because the court explained that the purpose of plain error review is to avoid wasteful or purely symbolic reversals. And so if petitioner had objected in the district court—
It wouldn't be purely symbolic. The defendant would get to speak.
But the very purpose is to ensure that there not be a remand that would not result in a different outcome and fairness of the proceeding. Now,
But you're begging the question, because the fairness of the proceeding is in giving the individual the opportunity to speak.
But the outcome would remain unchanged, even if the court believes
But the
that
outcome
were
is
true.
different. He's now spoken.
Yeah. Suppose the judge says, Mr. Defendant, I've reviewed everything your counsel has written. I've reviewed the pre-sentence report. I've listened to what you said on the stand at trial. At this late date, there is nothing you could possibly say that would change my mind. I'm sentencing you to a year in prison, right? Bangs the gavel. Court is recessed. No allocution is invited. Not even the letter is read, right? Nothing said to counsel. The judge announces there is nothing you could say that would change my mind. What would be the standard of review on appeal? Would you say, well, the judge said there was nothing he could say that would change his mind, and therefore that can't have been plain error?
Well, it would be distinct as between the two Olano prongs still, so that under the outcome—
Forget Olano prongs. I'm trying to see what the functional argument is. There aren't any Olano prongs in Rule 52. Olano's a gloss on a rule. I'm trying to figure out what the government's treatment of a concrete situation is.
Well, plainly, if there were no possibility of an outcome effect on remand, then according to Olano, the reviewing court would lack remedial authority.
But why would the reviewing court accept the judge's say-so? The judge says there's nothing you can say that would change my mind. That sounds like the very example of closed-mindedness that allocution is supposed to overcome. And it might indeed be a reason not only to reverse, but to send it back to a different judge for sentencing. Because when a judge says, my mind is closed, don't trouble me with the facts, something has gone fundamentally wrong in the process, has it not?
It would, of course, be open to the defendant on appeal to show that he might have said something different, something of which the district court was unaware when it made that statement, and that might change the way the reviewing court looks at its outcome analysis. In this case, petitioner only argues that he would have stood up and accepted responsibility, but that is implausible because he had already told the district court, I am not sorry for what I did.
Well, he didn't tell the district court anything. A letter was written that was never submitted to the probation department and was read by his lawyer, who didn't say, I've looked at the transcript, she didn't say, this is what my client wants me to read to you. She said, I think it would be valuable if I read you this. We don't know what the defendant would have said. Isn't that exactly the situation where there's at least some possibility that that the trial court missed something by not having the person speak?
We don't think so because petitioner on multiple occasions said on the record that he was not sorry or that he would do it all again, and the way that that got in front of the district court does not change the narrowness of the error here.
Mr. Greenfield, I invite you to go back to Justice Easterbrook's example. And there is something wrong in the foundation of your argument when the government would take the position, don't you think, that if a judge walks in and says, I have a closed mind, I don't care what you say, I don't want you to talk. Your sentence is 10 years and walks out of the room, that we're not going to remand. So what I'm looking for is an articulation of whether there is a difference in approach or if the approach is the same, but the outcome would be different, and then why?
Well, fortunately, that is not the error before us today, but if it were, the difference might be that the inferences against the defendant on appeal would be very different than they are here. The defendant might more credibly be able to say that he would have allocuted if personally invited, because the judge, according to that hypothetical, did not explain the right as the district judge.
Well, the judge
here
has
did.
said, I have a closed mind.
And so the defendant might also be able to more credibly say that he would make some new and material statement that would affect his sentence. Here, for the court to accept...
Let me give you a concrete example. This actually happened once in a case that I had some role in. The district judge makes the I have a closed mind statement, and he then turns to the defendant and says, I'm sentencing you to 5 years. I understand you have a right to allocution under the rules. I'm leaving. I'm going to lunch. But you stay here and read your allocution to the court reporter, who will write it down. The judge then gets up and leaves. What should the Court of Appeals do?
Well, the error there would be the lack of a meaningful right to allocute. This court has explained the right to allocution as a right to a meaningful allocution, and there the defendant appears to have been deprived of that right. Here, the error...
Actually, the defendant well knew that the judge tended to behave that way. Of course, he shouldn't be allowed to behave that way, right? And I would expect the Solicitor General to confess error in that case if the Court of Appeals should uphold it.
It does sound like an unusual case that might require a different approach on the part of the Solicitor General.
But isn't this an a fortiori case, then? You say that's no meaningful right to allocute, but the person is allocuting, they're standing up, there's no judge there. In this case, they didn't even get to stand up.
Well, in this case, the court should compare the error as it happened with the proceeding as it would have transpired without the error. And the difference is this. In the actual proceeding, the district judge said, your client, Mr. Garfield, has the right to allocute. And if the judge had cured the error, she would have said, you, Mr. Garfield, have the right to allocute. So in order to find an outcome effect under Olano in this case, the court would have to find that that change from the third person to the second person would have first prompted petitioner to stand up and allocute, would then have led him to say something of meaning during his allocution, that the district judge...
Who judges what's meaningful? If sentencing discretion is within the powers of the district court judge, how does a circuit court judge determine what would have moved the judge below?
Well, the question is particularly easy in this case, where petitioner's earlier statements had formed the sentencing judge's basis, as she explains on page 29 and 30 of the joint appendix.
Oh, but she actually says he would do it again. I am putting him in jail so he won't do it again, presumably meaning during the period of time that he's in jail. Now, we don't know if he meant I would do it all over again, but because now you've told me this is actually criminal and not protected by the First Amendment, of course I won't. Maybe he would have said that.
It is implausible to think that a defendant who describes himself as outspoken would have sat silently while all of the parties and the district judge misinterpreted his words. But
so
even
now
if he
the
had,
burden is on him to leap up when he hasn't been invited to allocute?
the question is not just whether he would have leapt up to allocute, but whether a more personal invitation at the outset would have caused him to do
Counsel,
so.
you're overlooking the obvious. I understood the defendant to be saying, I'm not going to stop talking about how I oppose the war. I think it's wrong. She, the judge below, appeared to believe that the defendant was saying, I'm going to misrepresent myself as bearing a naval cross. So how can you tell me it might not have made a difference in the judge's view if the defendant had explained his real statement? I'll do it again.
Well, I see my time is running short, but the short answer to that question, Your Honor, is that the district judge had said on the record that petitioner here had a history of deception, and so there is no reasonable probability that even if he had allocuted because of a more personal invitation, and even if he had said those things, that his sentence would have changed. Even if so, petitioner would still have to show an effect on the fairness of the proceeding, which he does not show under the miscarriage of justice standard, and so we ask that this court affirm. Thank you.
May it please the court. I would like to make 3 points on rebuttal. First, as to the First Amendment. The government asks for a new unprotected category of speech to be recognized today. They say as much. But we stand by our assertion it does not satisfy Stevens, and the reason is because the tradition of prescription they look to is illusory. The government cites to cases that, as Justice Sotomayor pointed out, are not just about falsity. They're about more than that. They're about defamation generally. In Brown v. Hartledge, which the government referred to for the proposition that the court would have had the lie that the candidate made been intentional, found it to be unprotected speech, there was more going on than that. That statute was a vote-buying statute. Had the lie been intentional, the candidate would have sought to procure votes and therefore office through an intentional lie that would arguably have been fraud. This is why Stevens warned against taking descriptions in past precedents to pose a general test. And this is why the tradition of prescription they look for is not what this court looked for in Brown v. EMA and Stevens. That was historical evidence of ongoing regulation of a category of speech, and that is not what the government points to here. So they do not satisfy Stevens.
How do you address the statutes that the government pointed to that make pure impersonations criminal, like the one that says if you claim you're a U.S. citizen, it doesn't require any kind of harm, or the statute that says you can't lie to a federal officer, doesn't even set forth a materiality component or a harm component to government operations. We have any number of statutes that make pure impersonations without harm violations of law.
For many of those statutes, Justice, I would say that the speech is basically regulated under strict scrutiny. The government has a compelling interest in preventing lying to secure benefits, preventing lying to say you're a citizen, preventing lying to a government tribunal. And the government makes very little effort here to show that this statute would satisfy strict scrutiny. Certainly, the interest involved is not as great. Rather, the government
But why would anybody, except for Halloween or a movie, anyone who dresses in a Navy outfit and wears a Navy cross, or anyone who claims to have received one, inherently they're seeking a benefit, either greater respect from others or admiration, adulation, a date. There's something and a reason and a benefit that they feel they're deriving from the act.
They certainly may be seeking a benefit, but that benefit may be something such as validation, personal autonomy, interests that have been recognized by this court to be within the scope of the First Amendment. I would point you quickly, since I am out of time, if I may finish the answer to this question, to the long tradition this nation has of the use of pseudonyms in political speech. A woman may have chosen to use a male pseudonym in order to be heard. Representing oneself to others and making oneself heard has never been shown to be the sort of activity that's fraudulent. And when the government asserts that, and asserts that Garfield had a fraudulent intent, the way that he could have rebutted that would have been to appear and allocute. And I think this goes to the point that you made, Justice Sotomayor, at the end, and as well Justice Rubin. He had no chance to say what he really meant by he would do it again or he would keep doing it. We argue that he would keep expressing his genuine political beliefs, and we ask you to reverse. Thank you.
It's time to adjourn for the day. We'll be back.
All rise. All rise.
Please have a seat. Now, I know that the students have gone through rounds and rounds of moots, and that none of them were like the real thing. And for all of you in the audience who think you could have done a better job, come up front and give us a try. You guys. You guys were great. This is really hard. It's the hardest thing that you could do as a lawyer is to argue before the Supreme Court. And you've got one justice and two make-believe justices that are just as good. And the pressures are enormous. Your performance, as I tell every group of students that I've gone before who have performed the way you have, gives me hope for the profession. Really good. You inspire me about what's coming, and you awe me in how polished you already are. It really was a wonderful, wonderful performance. You've learned your skills well. Now, you force us to make choices which are never easy. We were back there because each person has tremendous pluses, and there are areas where some things could have been done a little bit better. But overall, the performances, each one of you was spectacular. But choose we must, just as choose we must when we're deciding hard cases. We have to break the ties, and so that's what we were forced to do. Having said that, the vote of the judges was that best team were Carolyn Anderson and Matthew Greenfield. Best brief was Jessica Palmer and Adam Hallwell. You guys had a harder job. And the best oralist was Matthew Greenfield. I hope that those in the audience take my words of warning to heart. It's very hard what these guys did, and they did it very, very well. You've given us tremendous food for thought tonight. Both issues that were being argued are issues that are still open in the courts. Although I saved you from questioning you and asking you, was then Judge Easterbrook wrong in the Noel case? I really thought of asking you to explain why, but I didn't think that would be fair, okay? So it is wonderful, and thank you. I don't know if my two colleagues have anything to say, but...
I have a few things to say. And of course, having been a professor of law, I always speak in 50-minute increments, so I'm sure you'll be patient. The first time I watched a moot court was in the spring of 1971 at the University of Chicago, and the center chair then was Justice Harry Blackmun. And at the end of the moot court, Justice Blackmun said something similar to what Justice Sotomayor just said. He said in particular that it had been a wonderful argument, and he looked forward to the day when all four of the advocates appeared in his court. And there I was a first-year student, and it occurred to me that Justice Blackmun was just trying to be polite, because obviously these were law students. When you go to the real Supreme Court, the real advocates, the peak of the profession, will be obviously doing much better. Then I became an advocate in the office of the Solicitor General, and I realized that Justice Blackmun had been exactly right. He was not being socially polite. He was telling the truth. And so was Justice Sotomayor. I mean, it's not simply that we will all look forward to seeing you. This was real excellence in oral advocacy, and we're not just trying to flatter the students. Dean Minow said at the dinner that one thing I have said about appellate advocacy, she's trying to scoop me here, is that a really good appellate advocate is having a conversation with the court. And it's one of the most extraordinarily difficult things to do that you can imagine, because the judges are not only up on the raised bench, and they're not only wearing black robes, and they're not only older, but the advocate knows that the judges are going to be deciding the case, so there's always this sense of deference, or am I going to say the right thing? And it's very hard to have a conversation with somebody when you're worried that this person is actually going to decide and you're not sure whether you're right. On the other hand, the big difference between oral advocacy and the brief is this long monologue in which the judge may have written a lot of questions down, either literally or figuratively, in the margin of the briefs. And there was no opportunity for an exchange, so the judges got puzzles or problems or wonders. And an advocate who really does the art of oral advocacy well, and I refer to it as an art because that's what it is, an advocate who really does that uses the opportunity to get the judge to express the questions that have been written in the margin of the brief, and then wants to talk to the court about it. An opposing style of advocacy which was, alas, practiced often at the Supreme Court by a former dean of this law school, who used to be Solicitor General. An opposing style was for the advocate to stare at the court and say, you know, some students in my class used to ask me questions like that, but it wasn't really very intelligent, and if you'll just stop asking questions, I'll tell you what you need to know. And for some reason, that doesn't
more
really...
More than one dean of this law school has been Solicitor General.
Oh, it's certainly not the most recent former dean. And I'm not trying to be too coy. I'm referring to Erwin Griswold. Erwin Griswold single-handedly got the Supreme Court to reduce the amount of time allowed for oral argument. And I was there when he did it, but I won't tell you the story of that. What I noticed today was that all four of the advocates viewed the questions not as distractions or not simply as things to be answered and then let's go about the argument, but as an opportunity to engage and expand on the argument. You find out what the judge is interested in, and then you run with it. That's one reason, of course, why it's such an art form. It's not anything you can practice. It's not anything that the traditional murder board or moot court before the real argument will prepare you for. It doesn't help at all. The only way to do it is to stand up in front of a real court and see how well you did. And I greatly admire the way these four advocates did it, and I must say I greatly admired the quality of the briefs in this case. So I think this bodes well for the future of our profession. Thank you.
All four of you were excellent, and I just want to emphasize how difficult the decision we had to make of who the best team was and who the best advocate was and who the best brief was. These are very, very close matters, and they were matters that we discussed and deliberated about rather than it being in any way sort of obvious on the surface of it. And I think the oral advocates, I'm sure now know, in some ways I'm sure this is harder than arguing in a court. First of all, you are arguing, but your friends, your family may be here as well, and for something that could be really, really nerve-wracking, each of you did a really great job. I also want to say that the briefs, that too was very, very close, and I want to acknowledge the other authors of the brief from both teams, from the respondents team, not just Caroline and Matthew, but Stephen Pezzi, Mitchell Reich, Stephanie Simon, and Noah Weiss, and from the petitioner side, the winning brief, Yvonne Sadi, Matthew Scarola, Benjamin Watson, and Avis Bolin are also members of the team who I'm in both cases I know are invaluable and equal members of the team with the people who argued orally. So I want to acknowledge them, and in fact I hope we all will acknowledge them.
Thank you. I hope we'll see all of you in the back. How's that? And we're now really adjourned for the evening.